to make sure that we are indeed maintaining the best practices we can to ensure people's health and safety is protected. So we did that on March the 13th. And the next week after that, so that was on a Friday, the next Monday, we had asked about 20 judges in our state to test out some platforms for remote hearings. And by the end of that week, it was clear. The judges had said, this absolutely can work, let's do it. And so by early the next week, so within about 10 days of that first emergency order, we had our entire state, all of our courts, all of our 3,000 judges, we had licenses for them to use what we chose, the Zoom platform, to be able to begin to conduct remote hearings. And so now, what is that, almost 8 months later, our courts in Texas have heard almost 750,000 remote hearings. 2.2 million people have participated in those hearings, and 1.7 million hours have been spent in remote hearings. We have seen that in every type of case, in every type of proceeding. In fact, I was telling the panelists before we started this morning, I was a little late getting here because I couldn't pull myself away from the 2 remote jury trials that started today in Texas. We have remote jury selection going on in a civil court in Dallas, and remote jury selection going on in a criminal trial in McKinney, which is just north of Dallas. This is not our first virtual jury trial in our state, you may know, but it's the first time we've had 2 at once, and we will see more throughout. And so we've seen the quick embrace of technology, and that's that 750,000 hearings. The interesting thing is that number continues to rise every month to month. It's the number we're having per month is continuing to go up. And so we're seeing a large embrace of that. If I look at the largest users of that, it's not like there's 1 or 2 or even 10 judges who are using it significantly more than others. It is broad and widespread, and courts are being able to move their dockets and their cases that way. Our Supreme Court's order still requires, the most recent one was issued last Wednesday, still requires judges to use remote proceedings if it's reasonable and it's possible to do it remotely. So we're still doing everything remotely in our state. And of course, as the pandemic heats back up and the number of cases spike in our state, there's more and more pressure to do that. There is some ability to do some things in person, but still primarily everything's happening remotely. So what have we learned about that during the pandemic that is important for us today? One, as I said, we know that we can use remote technology to do hearings in every hearing, every type of case. We know that virtual jury trials can work. In fact, perhaps in some ways they might work better. As I was watching this morning, the jury panel answering questions, I began to think about what it was like before when we had in-person jury selection. And when I'm comparing the virtual jury selection with the in-person jury selection, it makes me realize how much more willing to share information and engage the jury panelists are than they are in person. And it also, as I look around and view not only the jury selection, but also other types of cases, I realize that we're seeing, and this is not just a Texas phenomenon, increased participation. Some judges are reporting 100% attendance at their court hearings. This is not something that we're used to. We've seen sometimes 30, 40, 60, even 75% of the participants in court cases not showing up. All of a sudden, we've seen that change. The barriers to participating in court hearings appear to have been removed by having remote selection. So maybe it wasn't people just thumbing their nose at the justice system all along. Maybe it was, in fact, true barriers like transportation, childcare, jobs, and economic issues. And so I think that's been really interesting to watch. It's so significant that many of our judges have had to change the way they docket because more people are showing up. So no longer can they handle those 50 cases an hour. It now takes a lot more time because now people are participating. And I think all of us would agree from the court side that having the litigants participate in their cases is really important and a really positive benefit. We've seen increased judicial efficiency. Not to say that everything is more efficient, let me be clear, and not to say that every case should be heard remotely, but we've seen some increase in judicial efficiency where perhaps judges who in our state who travel no longer have to travel to do that. They can do it from their homes or their offices. We've seen the ability to handle short hearings much more efficiently than people waiting around for hours for their 15 minutes of their case time. So I think we're seeing that across the board and are really excited to study that further to see what efficiencies we've gained that perhaps could hang around. We've seen increased access to justice. We know that in the past, there have been barriers to access to justice. For instance, perhaps a lawyer is willing to come on and help someone free of charge at pro bono in a case, but whenever it takes 2 hours to drive to that location, or even an hour to drive to that location and back, perhaps there's less likelihood that that attorney is willing to take that case pro bono because of the cost to them or their firm. But of course, if they can be working on a paid case, sitting at their office, waiting for the judge to pop them into the Zoom room where they can do their 15 minutes, all of a sudden we open up new ways to do that. Or in our instance, in our state, interpreter access. We've seen an 80% increase in the usage of our staff interpreters at our office through remote technology than ever before. Many places in our state have no interpreters within 200 miles of the courthouse. All of a sudden, through the use of technology, that can be resolved. Court reporters. We have an issue with court reporters in our state where we don't have enough in the right locations, and so many judges are oftentimes left searching or trying to figure out how to deal with that. And so that's obviously one of them. Of course, court electronic recording is there, but many of our courts still use court reporters, and and remote technology has allowed that to occur. We've also seen, of course, an increased need for technical staff. Just because you can now use Zoom doesn't mean everyone's an expert. And we've seen increased time needed to assist litigants with that. So I think the key is that we found benefits to this. But at the same time, I think other things are going on in our world that we need to be aware of. One is, of course, social justice issues. Now more than ever, I think courts are focused on this issue. The CCJ and COSCA annual conference this year was focused pretty much solely on this issue. And I think you have a recognition by courts and judges alike of a need to make sure that we're looking at what we're doing, we're evaluating our data, and we're making sure that people are not treated with bias or implicit bias or any other types of equity issues, or that people, even if they're not, that they're not feeling like that, and that the courts can evaluate that in a way that is meaningful. So we do, and I think the other thing too we have to look at is what role does technology play in making sure there's social justice and equity. As I looked at our remote jury selection from San Antonio a few weeks ago, I got the data about what the representativeness of the jury was to the community. And the exciting news from that is it was absolutely representative of the community, something even from our communities which have in the past not been represented in those panels. So we've seen an ability to allow people who might not will otherwise be able to participate, and that certainly moves the ball forward. So where do we go from here? We first of all, we know that we're likely to be in the same posture for many months to come, despite the really great news over the last 2 weeks of 2 vaccines, highly effective vaccines being produced. And of course, hopefully those will soon be approved. But even if they're approved tomorrow, all the indications are that it's likely to be 6 to 9 months before the general population has access to those in ways that we can really truly begin to return to normal. And so first of all, I think the key thing for you and for us to think about is what do we do between now and then? One, of course, we can just sit here and say, well, what we've done works good enough. And so we can just sit back and wait for this to be over. But one, I think that we've got opportunities to really think about how can we continue to improve upon the experiences, the tools that our judges and court staff and litigants and parties have. And so I think that's one thing we need to think about. It's not gonna be over next month. So we ought to do, excuse me, we got to do our best to make sure that the tools and applications are available to those individuals that need them now. The other thing I would say is that this has been my hashtag for many months is hashtag not going back. One of the most frequently made comments to me or questions asked to me is, are you going to take away our Zoom licenses? This from judges. We've seen litigants, lawyers, judges fully embrace technology as a way to do this in ways that, as many of you who've been in this field know, many times technology takes a long time to get embraced. I've said that we've been able to do more. We were able to do more in 2 weeks than we were able to do in 20 years because of the pandemic. And so I think what we've seen is people understand the value of how rethinking the way we're doing things can perhaps make things better. And so I think we're at a place where maybe for the first time, we have judges and court staff and attorneys and others willing to embrace technology to meet needs and really to rethink everything we're doing, because the pandemic broke the whole thing. We had to pretty much piece it back together, perhaps for the first time ever. And so we should take advantage of that opportunity. We know that even when the pandemic is over, there are things that we're going to take away from the pandemic that are beneficial to the court system. And so we think that it's important for the courts to really take a look at that. So I hope that throughout the rest of this session and today, you'll think about how you can play a role in that. We as courts need the industry to partner with us to think about how you might be able to assist us. But I think the key message is, as Joe mentioned, the world has changed. Everything has changed. The courts have changed. We won't be the same. And so we really have to think about the systems that we have in place, the technology we have was built for a different time. We don't need those same technologies in the future. And so I look forward to talking with you more about that throughout the morning and the day. But I think it's important for us just to realize that everything has changed and you play a role. So with that, I'll turn it back to you, Joe.
Thanks, David. I appreciate the framing and insights that you're providing here. I'd like to bring up another member of the Joint Technology Committee and the Chief Judge of the Arizona Court of Appeals, Judge Sam Thuma. Judge?
Joe, thank you. And thank you, David. It's a pleasure to be here remotely. And as is always the case, I learn far more from the other speakers than I impart. But what I wanted to focus on today was some things we're seeing in Arizona that are, I think, wonderful from a technology perspective. And believe me, I'm an optimist. I look for those layers of light, or those rays of light in a pretty dark cloud that COVID-19 has cast over all of us for so long. But let me first say, why would a Court of Appeals judge know anything about what working judges, on the front lines are doing? And let me share with you how I have learned that. I chair, and I'm going to read off a screen because it's a clumsy title, but I co-chair the COVID-19 Continuity of Court Operations During Public Health Emergency Work Group. Okay, we call it the Plan B work group because Plan A left town when COVID arrived. And what we are, and we've met every week starting in early April with judicial officers around the state, judicial administrators, jury commissioners, court clerks, folks in the administrative office of the courts, to try to be an information exchange for how we can work through this pandemic. So it's the Plan B work group, and I'll use that as a shorthand. That's where my information comes. And we've done some white papers. A courthouse operations white paper was the first one that came out in May, and then jury operations in June, and then a protocol for how courts should deal with either close contact or exposure or symptomatic COVID-19 experiences in the courthouse. And we've now updated that protocol several times, got some terrific information from the public health folks at the University of Arizona that helped us on that front, and updated it most recently when the CDC redefined close contact not so long ago. And then we've done a bunch of trainings for folks around the state, including basic things like the differences between different remote platforms, and then a deeper dive into remote platforms, and then what some courts around the state are doing, both big courts and small courts. Maricopa County is one of the top 5 superior courts in the country, or state trial courts in the country in terms of volume. I also serve a county called La Paz, where there's 20,000 people and 1 judge. So we have enormous sort of differences. But let me kind of mention just real briefly 6 things that I have seen, and I'm so impressed with what trial judges, both general jurisdiction trial judges and our limited jurisdiction trial judges, our justices of the peace and city courts are doing, that it just makes me so proud. And so trial judges have always been my heroes and those who work with them, and that's particularly true in the COVID-19 world. The first is jury issues and how to use technology both to summons and get additional information from jurors. It used to be that surveys were only used in those big capital cases where, you know, you'd call 300 people in for jury selection. Well, not so in the COVID-19 world. Judges are using electronic summonsing function and information to be able to determine hardships, so folks aren't even coming down to the court when they're excused, to limit foot traffic there. And I can tell you they're good and they're helpful. I've been summoned for jury service on the 17th of December, and last night I filled out my information on those very topics. So a really good use of a technology that's been out there for a while, but oftentimes was reserved for the most complicated cases. Remote hearings, of course, hearings, trials, bench trials, jury trials, grand jury proceedings in some of our counties as well. And again, a service to the public and the people who are involved. We have enormously large geographic counties, maybe not by population, but at times people would need to drive 2 hours to be able to get to the courthouse to participate in a grand jury proceeding. They can now do that by commuting 15 steps from their kitchen to a quiet space in a way that allows their experience to be a lot different, and I think a lot less intrusive than it was sort of in the pre-COVID world. Third point, e-filing. We have had the good fortune, our court has basically been paperless since I began 8 years ago. And now a lot of our trial courts were e-filing courts before COVID hit, but that's been accelerated to statewide. Again, the real need for using technology to avoid contact that can be avoided. The fourth thing, kind of the evidence portal concept, and this is something I chaired a task force on court management of digital evidence. We issued a report way back in 2017. It was October 2017 in response to a JTC white paper about what if we treated evidence, documentary evidence, like we do e-filing and like we do court reporters' transcripts that are done in electronic files that are not attached to a thing, not attached to a CD, not attached to a thumb drive, something like that. And really the paradigm for that was body-worn camera footage, which is becoming more and more prevalent, of course, in criminal cases. But again, the concept of the digital portal to receive that evidence as opposed to a thing having to come across the threshold into the court. The fifth thing, sort of creating the record and keeping the record, and again, how we best use our most precious resources. Every minute of in-court time, of course, is a precious resource. Every minute of a court interpreter's time is a precious resource. Every minute that a court reporter is taking notes in a live proceeding is a precious resource as well. How do we best use those resources? And then the final thing, and this is sort of the miscellaneous other in this list that I have, is scheduling and other innovations that I have just been so incredibly impressed with some of our courts who really don't have two nickels to rub together are doing the most amazing things. One court, for example, was trying to figure out how do we eliminate the crush of people in our common area waiting to see a judge in a high volume court. Well, what'd they do? They went on either eBay or its more modern equivalent and got pagers, a set of pagers like restaurants used to use when you'd put your name in and then the pager would go off. So folks who are waiting for their hearing could wait outside, especially in the cooler months in Arizona. That's a better thing. And then the pager would go off when their hearing was about ready to be called, so they could stay socially distant and then go into a courthouse that allowed social distance as well. Not an expensive tool, but a creative tool, really thoughtful tool. Same thing with sort of staggered jury appearances when folks are coming in for jury selection when it's in person. Instead of having 300 people in one room that all need to be there at 9 o'clock, to stagger the appearance times to avoid large mass crowds where social distancing is impossible. Physical plant, using creative ways to look at a physical plant, using the Board of Supervisors auditorium for jury selection that pretty easily allows for social distancing, as opposed to what historically was a cramped courtroom to get 60 people in if you had a serious felony offense where you needed 60 to start. And the other thing that I'm seeing too is jury selection is going a lot faster when the individuals come to the court, because a lot of the hardships have been pre-screened out using the technology that I mentioned. And then of course, staffing, using teams, team 1, team 2, and staggering when they appear in case someone on the staff has close contact or is symptomatic for COVID-19. So just the unbelievable creativity, much of which is allowed by reliance on technology and the expansion of technology, and just the incredible creativity that courts are doing. Trial courts and those trial judges and those who work with them really are my heroes. And what I have learned as well in this is it's not just our general jurisdiction Superior Court judges who sometimes have wildly high volume cases, but the justices of the peace, the city court judges, some of whom on the justice of the peace side are not law trained. Their innovation and creativity is just unreal as folks really try in almost impossible circumstances to use technology to better serve the public in ways that I truly and firmly believe, some of which will stay once we get that golden ticket, the vaccine that David had mentioned, that puts COVID-19 in our rearview mirror. These things have taught me that we can better serve the public using technology in ways that David had mentioned and in ways that many of you know. So again, that's my experience in the COVID-19 world. There is a huge technology component to it. I would shudder to think where we might be had this been the millennial new year as opposed to 21 years after, where we really can use technology in ways that help serve us all and help folks who access the courts and are required to access the courts can remain as safe as possible.
I really appreciate those insights, Judge. That really kind of helps set the table for some opportunities that are out there and some of the cool things that have occurred already. We all are aware that technology and change takes capital investment. And today we have the opportunity to hear from a leader that manages some of that capital investment. I'd like to introduce Jonathan Mattiello, Executive Director for the State Justice Institute. Jonathan, how about your thoughts?
Thank you, Joe, and it's great to have the opportunity to meet with all of you today. I did prepare a couple slides just to kind of guide through the conversation. It's a great opportunity for SJI because, while we've had great interactions with the National Center for State Courts, CTC, CTAC, the Joint Technology Committee, and all these other great court-based associations and conferences, we have only had sort of limited conversations over the years with IJIS, so it's a great opportunity for SJI to let you know who we are and what we are doing around technology and have been doing for years, obviously pre-COVID, but certainly COVID has changed the world that we're operating in as well in terms of our funding priorities. Alex, just next slide. A little bit about SJI. We were created by Congress in 1984 to improve the administration of justice in state courts. Some of you may remember the LEAA days where there was federal funding out of the U.S. Department of Justice carved out for state courts. And when that funding went away, SJI was created by Congress to fill that gap in grant funding. And that was our mission and continues to be. as we move forward. We're governed by a board of directors, and by statute, they're made up of state court judges, including chief justices, a state court administrator, and 4 members from the public, 2 from each political party. And we're structured very similar to boards and commissions in the federal government. We are a nonprofit corporation that's 100% federally funded. So we have sort of this quasi federal government oriented approach. As I mentioned, we're appropriated by Congress each fiscal year. Our budget to do all these great things that are out there this fiscal year, we're still waiting because we're on a continuing resolution. Last fiscal year, our budget was a little over 6.5 million. So not a lot of money, which means that we have to make sure that every project we fund has bang for its buck and can be shared and replicated across the country. We award grants not only to local and state courts, but also to court support organizations that are working on national court issues. Some of those organizations, like the National Center for State Courts, the National Council of Juvenile Family Court Judges, the National Judicial College, the Center for Court Innovation, and there are others out there that are doing these national level projects. So we try to both focus on these national level projects while not forgetting our state and local courts with their individual projects as well. And then we are really focused on data-driven, evidence-based projects, proposals. We want to look at things that are sustainable, that have that cross-sector collaboration, whether even if it's at the local level, and really important that can be replicated. We can't afford to help one court do a online dispute resolution project and then do it for every court across the country. What we want to do is show that it can work in 1 or 2 courts, and then have other courts adopt that technology, adopt those processes, and learn from the grants. Next slide, Alex. We have our priority investment areas that our board sets prior to the beginning of each federal fiscal year. Please visit our website, sji.gov. Under priority investment areas, you can see what those are for fiscal year 21. These are not in ranking order, but these will give you a sense of where we are trying to encourage applicants to focus their efforts on, and it also shows where SJI and the SJI board is placing its priorities and investments in the limited amount of funding that we have. And within these priority investment areas, there are categories that are more specific. So please take a look at that. But very quickly, there are 5 priority investment areas. First is opioids, dangerous drugs, and behavioral health responses, really looking at, we're not separating out like we used to substance use and mental health. What we've learned over the years is that they intersect in many ways. And what we want to do is invest resources in addressing that in a behavioral health approach. Promoting access to justice and procedural fairness. Next is reducing disparities, protecting victims, underserved and vulnerable populations. And I encourage you to take a look at some of the categories under that. Advancing justice reform. This includes criminal, civil, and juvenile justice reform. And then finally, what we're talking about here today, and is a major area for us, is transforming courts. And within that, technology plays a major role in transforming courts and what the courts of the future are going to look like. Next slide, Alex. Our technology funding priorities, we're really looking for those innovative projects that improve court processes and procedures, case filing management processes, reducing time and cost to litigants and the courts, providing online access to the courts so that litigants can solve their disputes online and not have to go to the court, take off work, for a 10-minute hearing. We're trying to avoid that. I think through COVID, we're learning that we can do that through technology and online access. But even before some of the technology overlays, really making these structural changes to the courts and the court processes, because you have to have those structural changes in place before you really try to overlay that technology. Because if you're overlaying technology on existing processes and procedures, that aren't necessarily working well, then you're going to find that perhaps your technology may not be the best solution either, and may not be working as well. So having courts really look at case triaging in advance, how they're going to implement that, rules changes if that's required, workload realignment, really thinking about having those things in place prior to implementing an online environment, a technology environment. We really value a system change approach as opposed to just replication of narrowly focused programs and projects. And we're looking at technology and innovations such as online dispute resolution, portal development, virtual hearings, and other efforts that we've been funding to allow court business to be conducted outside of the courthouse. And I'll give you some examples of those next, with the next slide. So some of our recent technology grants, and some of this is before and after COVID, but the ones I'll talk about here on this slide to start out with were projects that we've implemented either right before COVID or right after. I had mentioned online dispute resolution, and this is an area that we are really interested in and have already done so much. Some of these projects include in Iowa, where we've helped launch with a funding landlord-tenant online dispute resolution pilot. In Tennessee, and medical debt in the Nashville area, really issues there with the local hospital systems and getting the litigants together to figure out these medical debt cases online rather than what ends up in a lot of these cases, landlord-tenant medical debt, foreclosure with just default judgment. I mentioned foreclosure and eviction in Ohio. There's some online dispute resolution pilots that will be launching there. In Utah, this was pre-COVID, but we helped fund the Utah Supreme Court and AOC to develop a small claims online dispute resolution platform internally. They have a very robust and skilled IT staff that was able to develop the software for that. And we've taken that software, and we're now working with the Pew Foundation to adapt the code and do that code review so that other state courts can implement the code without having to just be handed it off and not knowing what to do. So we're very excited about that project, because we're taking what was developed internally and we're making it available nationally, and we're hoping to have something out on that in the next couple of months. In New York, so Utah and New York were the first two ODR projects that SJI funded. In New York, this was a small claims platform developed commercially. So it was really interesting to have both launched at the same time to see and compare between what courts can do internally, if possible, but for many courts, it's going to be commercial products. During COVID, we launched a request for assistance around response and recovery activities, and we awarded a grant to Puerto Rico, who had launched this emergency petition email filing system, and we are now helping them link that in with their case management system and become more robust so that this will be a permanent solution for emergency petitions 24 hours a day, and will be able to be reviewed much quicker. In Shelby County, Tennessee, we're helping with an eviction settlement program that is providing a database on the litigants so that the courts and the whoever is there working with the litigants can determine if these properties are protected from eviction under the CARES Act. And then a court technology component model for case management systems. This is a project that's been ongoing for a couple of years now, but this is really focused in on developing this component-based approach around technology solutions that can be implemented independently with case management systems. This would allow our courts to have more flexibility. It will allow our vendors to know what works for the courts. Next slide. Just a couple of other ones I'd like to mention. We've helped develop e-learning modules for online mediation programs. In Minnesota, several years ago, our funding helped them build an in-house online conservatorship program, and also following that, an online guardianship program where guardians and conservators can now file their reports online. Courts can see those reports and be able to more accurately have a system in place for checking red flags and inconsistencies in reporting. In Alaska, we're picking up where Microsoft left off, working with Pew and others to continue the content development around their legal access portal. This portal has also been launched in Hawaii as well. So that it's very important to have the actual content driving behind that. Cybersecurity is a big area for us, and all of you know the threats and vulnerabilities and how our state and local courts have been impacted. We have funded cybersecurity assessments across the country for state and local courts, developed these national tools that are available to implement the best practices around cybersecurity. And again, we have these great partnerships with all the folks that I mentioned before to continue this, and certainly we welcome our partnership with IJIS. So that is what I have. I believe that's the last slide, right, Alex? Oh, and also I had mentioned this before, but really supporting these technology projects that are moving with cutting edge capabilities. One note, I'm glad we went to this last slide, is that we're prohibited by statute, but for funding operational cost of technologies such as equipment, Zoom licenses, court personnel, things like that. But what we can support is the expert consulting software development to implement these new types of technologies. And then, looking ahead for us, and it's great to have this discussion today because we are really interested in the use of artificial intelligence in court operations, that natural language processing, helping the courts use these tools to have more prediction around cases. It will help with case triaging. What's this going to look like here in the future? But we're very interested in those types of projects, especially around ODR. And we're really interested in new case types around ODR. For example, we've talked even with courts internationally about some of the things they've done. And for example, in the Netherlands, they've implemented divorce cases virtually all online. So we would love to continue finding courts that would want to test those technologies here. And so, and always the overlay in all this is taking into account both access and fairness. So I appreciate the time, and I'm happy to answer any questions about SJI and what we do. Thank you.
Thank you, Jonathan. Now I'd like to bring on someone with an appreciation for what it takes to implement and operate the portfolio of technologies required by courts for their operations. We are joined by Bob Rath, CTOC member, also a recent CTOC executive board member, and the Chief Information Officer for the Indiana Supreme Court Office of Judicial Administration. Bob, how about your insights?
Thanks, Joe. Good afternoon, everybody. It's my pleasure to join you today. I think the title of this session is quite appropriate. The world has changed. In most years, a title like that might seem like hyperbole. This year, the name fits. Everything's changed. And I joined the Office of Judicial Administration in 2009 as Director of Appellate Court Technology. And as Joe mentioned, I served for 8 years on the executive board of CTOC. In November of last year, November 2019, the Indiana Supreme Court launched the Innovation to explore ways to make Indiana's system of justice more efficient, less expensive, easier to navigate. And we spent the last year exploring opportunities in family law, small claims, evictions, technology, and all that around a pandemic. A civil litigation team is being assembled now as well, a civil litigation subgroup. And my new role as Chief Innovation Officer, it was newly created in 2020 to help lead this effort. So to start with the fundamentals for our context, for our world, that's case management and e-filing. And luckily, many courts have implemented modern CMSs in recent years. And I think that everyone realizes the immense value that this investment has brought, or could have brought, during this pandemic. In Indiana, we completed our statewide e-filing system last year with the last county, number 92, integrated with the Indiana e-filing system. And filers can choose from about a dozen different e-filing service providers. regardless of the court they're filing into. And I simply can't imagine working through this pandemic without having completed the e-filing system and having a case management system on the back end. The ability for attorneys and self-represented litigants to file electronically and for court staff to process the documents electronically, that's become an essential feature. It's no longer a nice to have like it used to be. It's really a must have, especially now that people are working from home. They need to work with electronic documents, not paper, especially not paper that can carry a deadly virus. And modern CMSs and e-filing systems have enabled improvements in many other ways in public access, litigant portals, attorney portals. They've enabled so many new features that we're still early in the evolution stage. But especially with COVID, the need for new features is exploding. The entire world is scrambling. The world has changed. We can't expect everybody to show up at court tomorrow at 9 a.m. It's just not an option. So that a number of features that have been enabled through the modern CMS is text messaging. Text messaging has never been more important. We can reduce failures to appear simply by sending a text message to remind litigants and potential jurors that they have an appointment in court, even if that appointment is for court online. And reducing failures to pay with more flexible payment options is also an important opportunity. Especially in COVID, we can't have people going to the clerk's office to tender their payment, to pay a fee in person. Accepting payments online is a good place to start, but I have to congratulate Chief Judge Thuma. Arizona courts are working at stores like the Family Dollar and 7-Eleven. To me, that's just an amazing example of good customer service. And it's already been mentioned today, online dispute resolution shows great promise in this area. We're preparing to launch in Indiana pilot programs for debt collection and family law. And a pandemic certainly brings to light the potential benefits of ODR. It's really a big deal. And something surprising to me anyway was that scheduling a hearing has become more complicated today than it used to be. Court backlogs have grown due to COVID, but attorneys and litigants are working remotely and their schedules are more difficult for them to control. So hearings are sometimes scheduled and rescheduled again. And it takes effort to schedule these hearings in whatever platform the courts are using, Zoom, WebEx, or Teams. All that is extra work. Then you have to issue the order, the scheduling order, serve the parties, let them know of the contact information, the meeting information in order to join the online hearing. In many courts, this is just much more complicated than it used to be. If anybody has great ideas on that topic, I'd love to hear from you. But clearly the need for rapid enhancement is dire. We're fortunate to have technical standards tailored to our industry, and these allow new features to be developed for a broader audience, perhaps a national audience. We don't all have to work independently, developing from scratch to match our own particular situation without regards to what else is going on elsewhere. The technical people on the call have probably heard of the Court Technology Framework, Legal XML standards for electronic case filing, the National Open Court Data Project. It's nice to see from Jonathan's presentation that SJI is helping to fund the court technology component model for case management systems. These are really important. And in this pandemic where the need to be flexible, agile, respond quickly to change, it highlights the value of having these standards to consider, to build around, to build towards, and maybe it'll make it easier for courts to share solutions with each other, or make it easier to implement a vendor-provided solution if they're all speaking a similar technical language. Shout out to California. California's Court Stack project is an excellent example, I think. It's an award-winning example of a collaborative approach to building enhancements that would benefit a broad audience. You know, they designed for sharing from the ground up, and I think it's an excellent example. So these standards are important factors for court leaders and vendors to consider. Another area is virtual hearings. Virtual hearings have been a niche solution for quite some time. In Indiana, popular for connecting courts with offenders in jails or in state prisons. Our innovation initiative identified virtual hearings as an opportunity in our very first meeting in November of 2019. Now virtual hearings are a way of life. They're everywhere. We have, in Indiana, it's a non-unified judiciary, over 700 licenses for Zoom. Courts are conducting hearings all over. Other courts are using WebEx or Teams or other platforms, but the need for online hearings is evident. And this topic will be covered in more detail in this afternoon session. But I did want to mention that our court launched a pilot program recently where judges can request the service of a certified court interpreter to join a virtual hearing. The interpreters can be anywhere, and as David alluded to this feature earlier, where if you have online hearings, now the interpreter can be anywhere. They don't have to come to the courthouse. With our pilot program, a judge will post a request on Slack for an interpreter, and the first interpreter to confirm gets the gig and a link to the Zoom hearing. It's like an Uber driver or something. It's a gig economy, and it's still early in the pilot, but perhaps it's an idea that will live on beyond this pandemic that we're in. And there are other pilot projects underway. Even though courts are holding their hearings virtually, some people are still showing up at the courthouse. Either they didn't realize that the hearing was on Zoom or was virtual, or they didn't know what to do. So Judge Kimberly Bacon in Marion County, who's a member of our technology working group in the Innovation Initiative, has offered to pilot a number of different initiatives. We configured several meeting rooms that were adjacent to her courtroom with video conferencing equipment. So now if people do show up, even though the judge isn't in the courtroom and the hearings are virtual, they can have a Zoom room to join the hearing virtually. And we're working with Pro Bono Indiana to establish legal aid clinics over Zoom, where the attorneys can be anywhere in the state helping clients in these Zoom meeting rooms in the courthouse. Even the paralegal doing the intake can be virtual. And this will then expand to connecting with clients who can be anywhere over remote Zoom as well. As was mentioned earlier, that should get easier, hopefully more attractive for attorneys to offer services pro bono if they don't have to take the time to drive to the courthouse, which may be on the other side of the state. They could just take some time off their schedule and connect via Zoom. And the technology working group is also preparing to pilot a system where clients can check into court remotely or from a mobile device. When it's nearly time for their case to be heard, they'll be summoned by text message to join the hearing online, or someday they'll get a text message to say it's time to enter the courtroom. We're planning to separate the judging from the introduction or orientation stage of the hearing as well. So clients can go through the orientation in a breakout room, or hopefully they can do so in advance. You know, the introduction that judges give at the beginning of every session, where many cases are scheduled at the same time. Well, if those instruction, that orientation is being done in a breakout room, the judge can be judging the parties that have already gone through the orientation, while other parties are getting the orientation. So one of the reasons that can be helpful to some of the small claims litigants is that many of them are limited by the minutes or data available on their mobile phone plan. And if they have to sit on the phone, voice or data, waiting for their case to be called when there are many cases on the docket, this will allow them to spend less time connecting over their phone into the court. So beyond the courtroom, I'd like to mention collaboration platforms. Now, these were critically important before, but now the office is closed. Everybody's working from home. Conference rooms are a faint memory. What do we do? Well, I'd hate to live without a collaboration platform, also known as an online productivity suite, like Microsoft Office and Google Workspace are two examples. It's so easy to collaborate on documents and spreadsheets, to work in groups, whether internal groups and even adding on external partners or participants. Tools like these they're much more than email or video conferencing. Teams and the Google apps, they're much more than doing a video conference like Zoom. They go far beyond that. And I really can't imagine working without one of those services. Indiana's appellate courts have been on Microsoft's online services for over a decade, and our non-CMS files have been in SharePoint or OneDrive for years. We don't have any shared drives, for example. And over 90% of our staff already had laptops and were trained to collaborate online before COVID. So we were relatively well prepared to work from home, at least from a technology standpoint and a training standpoint. People already knew where to go to find their files, to collaborate, team meetings, to meet with their bosses, to meet with their colleagues. But now they had to do that from home. And so that brings up another topic, and that's cybersecurity. Courts had a difficult challenge managing cybersecurity before the pandemic, when everybody was in the office instead of at home. That's a big distinction because in the office, you're on the courts network that the court staff, the security specialists can much better manage the traffic on the network and the risks that come into the court. Now connecting everybody's home network to court systems increases the risk considerably. Doing so from a staff member's own personal home computer would increase that risk further. I strongly recommend against that, which we provided laptops to all of our staff, but that's something to think about. And cybersecurity is much bigger than we have time for today, but I needed to mention it. And please, the court leaders, be worried. The National Center for State Courts has information available on its website, and David Slayton presented a valuable webinar on this topic recently. That was an excellent webinar, David. I hope everybody can watch it. It's scary out there. You need a strong cybersecurity team. Luckily, you can contract a service if you don't have the resources in-house, but you really don't want to go without. So much has changed this year. We're in the proverbial new normal, and one of these days we'll get to a next normal. But before the dust fully settles, we should really consider what we've been through, what lessons we can learn from this pandemic, and where we can go from here. We need to avoid taking the path of least resistance, avoid returning to whatever our old normal was. Can we find a better normal? We can. We must. I like to say that silver linings are everywhere. We just have to look for them. Joe?
Thank you, Bob. I appreciate the insights and all those ideas that you put forth there. There's lots of opportunities that are out there. It generated a number of questions. And Sue, have you got a question from our audience that could fire up some discussion here?
I do, and also want to encourage everybody, because this really is a conversation amongst all of you as participants. So feel free to be putting your questions into chat and or to raise your hand virtually and just join the conversation directly if you'd like to as well. But we have had a number of questions, Joe, and one of the first ones was around the video hearings. And the question is, are courts saving the video and getting automatic transcriptions from hearings via Zoom specifically? And then how's that going? If anybody wants to comment on that.
So I'll start. Maybe Judge Thema can go after me just to talk about what they're doing in Arizona. Maybe Bob has more information about Indiana. But in Texas, we have advised judges that they can do what they want with the recordings. The official record of our court's hearings are still court reporter transcripts or court recording transcripts. Most of our courts use court reporters. And so most of them are not saving them and getting the transcripts from that. Of course, there's now the function that you can actually use through Zoom, at least, an API to get some automatic transcripts that are basically live transcripts. I know there's some discussion in the chat about that. But as far as from Texas's perspective, they are generally not being saved, although some judges are doing that just sort of as a backup. But the official transcript is still the court reporter's transcript or the court recording.
And that, Joe, that's consistent with Arizona's experience. There also, as I think David made reference to, there was a note in the chat that sort of the automated transcription is about 80% accurate. We just coincidentally post our oral arguments to YouTube, and I think that 80% number is about right from what I've seen. It gives you a rough feel, but it's not near what a good court reporter would get you.
Thank you, gentlemen, for that. Also, we have a question that came in to you specifically, Judge Thema, about being able to access the white papers that you had referenced in your conversation.
Sure, and I'm happy to give you a website. Now, I got to give you a caveat too. We have had the Arizona appellate courts have a hiccup with our websites that hit yesterday afternoon and is being worked on. So, and I just, Sue, before that question checked to see if it was fixed, and it's not yet. But the white papers can be found, the white papers that the Plan B work group has done can be found at azcourts.gov/COVID-19. Now, that's in a better technical time. If we were talking yesterday at this time of day, I know they would be there and you could find them. If you actually search, they've been posted a lot of different places, including the National Center for State Courts, Duke Law School's Bolch Institute, and other states have adopted those as well. So if you search Arizona Plan B work group, you'll probably find them. But yeah, someone has posted that, and in better days, hopefully by lunchtime in Phoenix, they'll be available on that website.
Good, thank you so much. It does look like we have somebody with their hand raised as well. Let's see, Jose?
Yes, hi, hi, can you hear me?
Yeah.
Yeah, great. Hi, everybody. My name is Jose Dimas, and I work for the PBSA, the Professional Background Screeners Association. I'm formerly with the National Center for State Courts. I was trying to put in a plug, kind of building on what Sam, Judge Thuma mentioned about reducing foot traffic and promoting remote access in the courthouse. You know, our members go to the courthouses, use the reading rooms, use the public access terminals to research folks that are trying to get a job. And so we have gotten some states, we have a handful of states that allow us to view these records remotely and kind of find out if the person who's trying to get a job as a truck driver, you know, if he has a DWI or things of that nature. And I was wanting to put in a plug-in for remote access and refer the group to a RRT, the Pandemic RRT, the Rapid Response Team paper about technology. And they kind of promote that, and I will link that in the chat. But it really just says that, hey, this technology has been around forever. we should consider, the court should consider giving more remote access to the public. So to reduce the infection for court employees and also our members who will sometimes have to go to the courthouse to research folks. So that's what's the kind of plug I wanted to put in. When this when the pandemic first hit, I contacted Joe Baxter, the court administrator of Rhode Island, and kind of made our points that we wanted to of course not get infected and keep court employees safe. So we're happy to see some of these arguments that I'm making about promoting remote access on that. And I open up for comments, see what folks are saying about that. But it would not be for everybody. It wouldn't be for Joe Q public. It would be for qualified users, companies. Our members are certified, they're bonded, they're insured, and they protect people's privacy, people's information, and personal identifiers as well. So I just wanted to put that out there for the group.
Appreciate your input. Thank you.
Can I just add one thing to that too? And this is really for the industry. I hope you all saw COSCA's policy paper from this year that was adopted in December or put out earlier this year, which speaks to that issue of, it's called Open with Care, which is about including, which is this pushing the states to open their data, to realize that it is the most, probably one of the most important things we have, and making sure we do that responsibly, but generally making it open and available. So, you know, the NODS, required NODS data standards that have been established, I would urge you to look at that. And I think from the court's perspective, I think you're seeing a lot of shift in that direction. As Jose pointed out, some of the reasons for that, but there are other reasons. And so I think that's important for industry to be aware of those issues. And if you're not familiar with the COSCA policy paper or the NODS standards, you should become familiar with them.
Absolutely, it's a great comment, David. We've also had a question out here around the use of YouTube in order to satisfy public hearing requirements. And the question is really around security and recording limitations using YouTube instead of other types of you know, platforms like Zoom. Anybody have comments on that?
So yes, definitely have thoughts on that. And I'll post a link in a second to something that we did in Texas. So we had a lot of discussion about this at first because a lot of the judges were very hesitant to put court proceedings on YouTube or anywhere. And especially in times where you have restrictions in travel by you know, the governor's lockdown order or whatever, and people can't come to court. There's a First Amendment to the U.S. Constitution right of the public to have access, and a Sixth Amendment right to the U.S. Constitution. So it's not just a Texas issue, it's a federal issue that people have a right to view hearings. And one of our judges said something which I thought was really good, that just because more people want to exercise their rights doesn't mean that we have to restrict them. So yes, not many people came to the courthouse to view court hearings, but you know, just because now everybody can see it from their home doesn't mean we should restrict those rights. It doesn't mean that we shouldn't balance privacy. And there are ways under those First Amendment and Sixth Amendment and the case law related to that to restrict certain types of proceedings or certain evidence or other things. And judges can do that very easily whenever it's necessary. But that's one thing. The other thing I would say on this is, and this applies to everything, and I think it's important for everybody to remember, is for some reason, when we move to technology, and as people who are involved in the technology industry, you probably see this all the time. For some reason, when we move to technology, we think that we're comparing against a perfect world. So everybody criticizes, well, the technology doesn't do this. And then I always say, and yes, neither did the in-person. So for instance, when you think about recording, everyone is really concerned about recording on YouTube, not remembering that just months ago, we were having issues with people recording in-person hearings as well. And so the same tools that we had to deal with that, we have today dealing with the remote technology. And if you watch Texas live streams, you'll see the do not record language on there. You'll hear judges at the beginning, you know, admonishing people not to record. And if people do, they violate it, then there are contempt proceedings. We've had at least one judge in our state who has held a person in contempt and thrown them in jail for recording something. And of course, this was an individual who did it sort of maliciously. So, I mean, there are ways to deal with those issues. YouTube may not be the perfect solution long term. Quite frankly, we might, you know, I know New Jersey has come up with a a way to use Amazon or the Azure cloud, one of the two, to basically create a streaming service, and that may be a better way. But again, that's sort of one of those things where you all as the industry can help us come up with solutions. At the end of the day, I mean, go to streams.txcourts.gov. You can see all of our courts streaming live. I mean, it shows right now, I just looked a second ago, there's just a whole list of live now. You can go watch the jury trials I talked about earlier. You can go watch just regular old court hearings. The public is watching. We've not had really any major issues with that. But it is something that I know we're always thinking about. But again, I just sort of go back to the point of we need to quit comparing versus the perfect. And you know, consider the fact that maybe what we're doing now is an improvement over what we had, and then try to resolve those issues that are still outstanding.
David, I couldn't agree more with what you said. And one additional wrinkle that we ran into with YouTube, we post our oral arguments to YouTube, not live, but recordings of the oral arguments, and they don't go viral. I mean, we don't get many people looking at them. But, and I'm immediate past chief judge, which is sort of the best position on earth right now. Peter Swan is our current chief judge. But when I was chief, I got someone saying, hey, you disabled the chat function for the YouTube postings, which we absolutely did, like the Ninth Circuit, I think, does, and many other courts around the country. And that's a public place where I have a First Amendment right to post my comments in response to reactions to the recordings. It was a sort of letter exchange. I wasn't impressed with that argument as chief judge, and I sort of declined the invitation to open up the comments portion of YouTube. But just know that claim may be out there, and someone far smarter than me will finally resolve it. I just didn't think it was the right thing at the right time.
Very good. We've got a question out here as well. So this is sort of being lobbed to industry, and that is with conferences, you know, our typical NACMs and CTCs and e-courts being virtual now. What is the best way for industry technologists to share their technologies with you practitioners and your agencies? And how do you know, what's the best approach, I guess, right, from the suppliers?
Go for it, Bob.
Yeah, an excellent question. And I wish I had an answer to toss out that would solve the problem, because that really is tough. I've seen several versions of this, and whether vendors doing a one-off, you know, invitation to see their solution, or being part of a conference, a virtual conference with an organizer and multiple participants and sponsors and the like. And I think the latter has worked better. I've attended several of these. I know the bar associations have done this, a number of other organizations that I'm interested in, and I've attended a couple of these. And I'd have to say that that would probably be the best, where if there were something like similar, I haven't seen the details of the coming eCourts presentation, but I suspect it will be similar to the in-person one, where there are experts presenting on certain topics, and you can take certain time to go and meet with the vendor in a separate room channel. I don't know that it would be as quite as good as being in person. Like if it were a permanent way of doing it, that personally, I hope it's not a permanent way of doing it. But on the benefit side, you can probably get a broader audience, or at least a broader potential audience of people who don't have to take the time out of the office and travel to a site to attend a conference. And hopefully the broader attendance, maybe, you know, you'll have people coming and going, only attending a certain few sessions or topics or whatever. But hopefully we'll find that more people actually attend part of it at least. So my personal opinion, and I've seen the several different options, I think the organized online conference like what the NCSC is planning for eCourts and what the bar associations have done recently, I think that's the better than doing, you know, one-offs where one vendor or one company doing their own invitations. Personal preference, I don't know, others may differ.
Yeah, I would add too there, you know, I think you're going to be seeing soon, especially not only in the courts, but really everywhere, really looking for platforms that are specific for conferences. I mean, to be honest, Zoom is not a good platform for conferences. It just doesn't work as well. And there are some platforms out there which specialize in that. I was looking at one the other day and talking with some folks where you can literally pop from like table to table. So you can like go find that, you know, the people that you would normally go to a conference and sit and visit with, you can like literally find them in the room and go sit at their table and visit. And you can pop in and out of breakout rooms based upon what's going on, just like you could do at a real conference. And so Paul Emily just put the name of the one I'm thinking about, their Remo or Remo.co. And so I think we'll see some of that. And my guess is that within, you know, we're going to be in the same position probably for the next 9 months or so, 6 to 9 months. So I think some of the conferences between now and then, you'll see some of that. And I agree with Bob. I think that's a good way to handle it, is to sort of have the ability to sort of try to replicate that in the future.
Yeah, I think if perhaps even from industry, if we can share with some of these associations, you know, the folks who are hosting these conferences, what we're seeing work better than other things, right? Because you're absolutely right, David. We've definitely seen certain platforms that are much more tuned into what those suppliers, you know, to being able to interact with the participants at those conferences than other mechanisms. So maybe it's just a matter of us making sure that, you know, everyone's aware that there are those capabilities. Joe, I want to get one more question in here real quick before we toss it back over to you. And that's a question that came in unrelated really to hearings and those kinds of things. But the question is, if a call center or a main number with a phone tree had been being used by a court traditionally, right, in your operations, how has that call center option been preserved as court staff work remotely and are using their own phones and those kinds of things? Has anybody tackled that?
So we are our office has been fully remote since March the 13th. We have a couple of staff who go in to process mail a couple of times a week, but other than that, our staff is 100% working remote and has been for the past almost 8 months, I guess over 8 months. That has actually worked really well. Thankfully, we had the tools in place to allow us to do that on a moment's notice. And the way we've handled the phones is simply, I'll get to, maybe Bob can tell the technical stuff behind this, but basically we use an IP phone system. And so basically we can forward those and basically mask it to where it looks like it's, you know, coming, you know, being answered by the actual phone there, but it's actually being forwarded to a cell phone that's provided to the employees who answer that off-site. Our voicemails all translate to email and forward to our email account so people can get those messages and respond. So it's worked fairly seamlessly for us. I can imagine there are places where it's not quite as convenient. It is not quite as easy to transfer calls. Obviously, you know, please hold, let me transfer you to so-and-so is a little more difficult, but taking messages and getting people to return has seemed to work pretty well for us.
Very good. Joe, I know we're running out of time, so we'll toss it back over to you. If anybody...
I might follow up, Sue, just real quick on that, if you don't mind, that IP phone systems are helpful. You can turn your computer into the phone so that when people call, you can answer it on your computer and they don't even know the difference.
Yeah.
Sorry about that.
Oh, that's
No worries, Bob. Thank you all for your ideas and insights and for attending the session this morning. I know we had some questions about virtual hearings, and I encourage you folks to attend the 3 p.m. Eastern Time session today, focusing on virtual hearings. I want to thank our panel today and thank you, Sue, as well. Special thanks to Alex McAdoo, who produced this event. And I've asked Alex to replay those cameos that you saw that started our event today in case folks came in late and didn't get a chance to see them. Those folks, I appreciate their input as well, giving you an idea of what they did to get through COVID and what sort of things they're looking for in terms of future investments from technology. So once again, folks, thank you again and see you at 3.
Hello, my name is Kelly Steele and I'm a court programs manager with the 9th Judicial Circuit Court in Orlando, Florida. Several types of technology have helped us during the pandemic, including our widespread deployment of Surface tablets and our ability to leverage existing remote appearance technology. However, using technology to conduct a majority of our hearings has presented both opportunities and challenges. Our main platforms for due process proceedings have been Cisco and Teams. We have used Zoom and Teams for non-due process hearings. During the pandemic, we have been able to incorporate our virtual remote interpreting and our digital court reporting services into some of these platforms. We're looking forward to some enhancements to Cisco and Teams in the next 6 months, including breakout rooms for Teams and Cisco Teams integration in the new year. Moving forward, we know we will continue to be challenged by requests for hybrid hearings where parties request to use multiple platforms. In order to meet this challenge, we are working toward wider deployment of cameras for our staff and in our courtrooms to try and make these hearings successful.
Hello, my name is TJ Beeman. I'm the District Court Administrator for the 10th Judicial District in Georgia, based out of Athens, Georgia. Go Dogs. I am also the current president of the National Association for Court Management. So on my behalf and on behalf of our thousands of NACA members, we appreciate the partnership of IJIS and its constituency. Just to share a couple of notes on technology in this pandemic time, I can certainly say on behalf of the 21 counties that I cover, the adoption rate of technology has probably pushed us probably a decade or more. We have been grossly behind in adoption of digital signing technology, video conferencing, online case management, even as simple as looking at our case management systems online, has been greatly behind the time. So this COVID time of sending our judges and our court staff home has really pushed home the need for video conferencing and remote digital signing.
I'm Sharon Blunt Baker, elected Circuit Clerk of Crawford County in the 21st Judicial District of Arkansas. We are a general jurisdiction trial court. In the COVID pandemic, our court utilized Zoom and Justice Bridge on iPads and laptops for the first time. We can improve our use of this technology by ensuring all courts have the connectivity, hardware, and software available.